right, well, we'll get started. And first, I want to say welcome to everyone, especially I see a lot of names I recognize on the list. So I know webinar format, you can't communicate back this way, but I see you, I recognize you. So thank you so much for coming today. So for those who don't know me, my name is Jean Hoffman. I'm Director of Coalitions at the Institute for Humane Studies. And for those who are less familiar with IHS, we're an academic institute who partners with scholars across the country to produce quality research on important topics in the liberal tradition. Our mission is to draw scholarly attention back to intellectual liberalism through civil discourse and its principles and critiques as we challenge presuppositions, sharpen our ideas, and cultivate an open academic community. So what this means is we support scholars throughout their academic careers. So we offer resources, partnership opportunities, and access to a passionate and supportive community. But in addition to fostering the development of these ideas within the university setting, we want to make sure these ideas achieve what we're calling escape velocity. So what does that mean? There are so many important topics and ideas being developed in the academy that are relevant to the live conversations going on in the world today. So IHS helps to get those ideas a seat at the table so they're considered when the important decisions are being made, not reflecting on the important decisions later on. So today's program is highlighting an example of this and how important ideas are for positive social change. So our three speakers have worked to develop, interpret, and communicate important ideas that are really relevant in this case. So as many of you know, in June, through Loper and Relentless, a case brought by the new Civil Liberties Alliance, the Supreme Court overturned a 40-year-old legal precedent that protected federal regulations from legal challenges. So this landmark decision represented a dramatic shift in regulatory policy and could limit federal overreach. So the speakers here today will not only address their role in these cases, but also how this production of ideas, so to speak, came to be. Before I go into introducing the speakers, I just want to give a quick note that the Q&A will be at the end, but you can submit a question at any time when the speakers are talking. So I'll be collecting the questions in a queue to ask the panel at the end. So as you think of a question, feel free to ask it so you don't forget it later. It won't interrupt things if you're submitting them as we go. So I'm going to introduce our speakers in the order that they will be speaking. So first we have Jonathan H. Adler, who is the inaugural Johann Verheet Memorial Professor of Law and the founding director of the Coleman P. Burke Center for Environmental Law at the Case Western Reserve University School of Law. This is where he teaches courses in environmental, administrative, and constitutional law. So in addition to many other subjects, he's published on delegation and administrative state issues, and his work was cited in multiple amicus briefs submitted in the Loper Relentless cases. So amicus briefs are written to represent individuals or associations whose rights will be affected in some sort of way by the decision in the case when they're not a party to the case itself. So it helps to address the larger fundamental issues in a case by providing the broader perspective to, the impact that the decision can have. So just 4 years ago, almost exactly to the date, he spoke at a program we hosted with the Pacific Legal Foundation about the separation of powers doctrine and the modern administrative state. So the intention of this program wasn't just to inform scholars in our network about important issues in administrative law. It was also to deepen connections between scholars who are working on research in this area and foster robust discussions about ways to address these areas. So it was to come up with ideas of what we can do given the issues that scholars were spotting. So his talk specifically addressed, is Chevron inedible? And it addressed what the future of deference could look like. And here we are 4 years later. So that after him, we have Will Yeatman, who's a senior legal fellow on the Pacific Legal Foundation's Constitutional Scholarship team. The Pacific Legal Foundation, or PLF, is the organization I mentioned before that partnered with us on a program on addressing the modern administrative state. So this was a great program. I was there. I didn't do the planning, but I got to benefit from being there. And it brought together, scholars, active lawyers, and clerks to discuss these important issues. And we really appreciate how much has come out of that partnership on that program. In this specific case, PLF submitted 2 amicus briefs, and Will was the author. So Will has a background in writing amicus briefs on controversies that involve administrative law, doctrine, in addition to researching regulatory reform, and he continues to address these issues in his current role. And then third, we'll have Mark Chenoweth, who's the president and chief legal officer of the new Civil Liberties Alliance. He has observed the administrative state up close and personal from perches in all 4 branches of the federal government. So he served as the first chief of staff to Congressman Mike Pompeo, as legal counsel, to Commissioner Ann Northrup at the U.S. Consumer Product Safety Commission, as attorney advisor in the Office of Legal Policy at the U.S. Department of Justice, and as a law clerk to the Honorable Danny J. Boggs on the U.S. Court of Appeals for the Sixth Circuit. In addition to all of that, he's also addressed regulatory work in the private sector as well. So his organization, the NCLA, represented the relentless clients in this case. So they defended fishing companies who were required to pay for at-sea monitors above their vessels, which violated the Constitution's Article 1 and exceeded the bounds of the statutory authority of the agency involved. So even though this case was related to fishing companies, as you'll hear, the implications of the outcome of the case will have far-reaching effects. So we'll just go through the speakers in order, one after the other. And so join me in welcoming Jonathan Adler.
All right, great. It's a pleasure to be here. I'm going to briefly talk about kind of the role of academic work in leading to the court's decision in Loper, Bright, and Relentless. I'll say a little bit about the cases themselves, just to provide folks with some background. So we're talking about the Chevron doctrine. We're talking about a doctrine that began sometime after the court's decision in a case called Chevron versus NRDC. And the reason I put it that way is because when the Supreme Court decided the Chevron decision back in 1984, they didn't think they were doing very much. They didn't think they were changing anything. They thought they were dealing with a fairly run-of-the-mill administrative law case involving what the EPA was doing to implement the Clean Air Act. And in particular, trying to figure out whether or not the EPA's proposed policy to lessen the burden of Clean Air Act compliance on regulated firms was consistent with the Act. And it turns out that is often the case. The EPA was dealing with a question that Congress hadn't thought about. The text of the statute was not clear about, and the agency was resolving as it was implementing the statute. In this particular case, what is a source under the Clean Air Act? Is it an actual smokestack or discrete point at which stuff comes out? Is it a particular building? Is it the entire installation, like a refinery, something that could be acres and acres? And the broader that definition, the more flexibility that a regulated firm would have. Well, in the course of deciding that decision, Justice Stevens included this paragraph that looked like a test, looked like a pretty formulaic test, a test that we're all became familiar with, test that my administrative law students have heard too many times, that when a court is reviewing an agency's interpretation of statutory language, that a court should really do two things. Step one is the court looks at the text of the statute, and if the text is clear, then that's what controls the question at hand, because Congress is the source of an agency's authority. Congress is the branch of our government that is supposed to be enacting the laws, and so if the law that Congress has enacted has resolved the question, we're good to go. We follow what Congress did. Step two was that if the statute is unclear, that courts should defer to reasonable constructions of the language offered by the agency. So if the court doesn't know what source means, Congress didn't tell it what source means, let EPA do it as long as it's reasonable. And after the court issues this decision, other judges and officials in the executive branch seize on this paragraph. And if you read the whole bit, it's a long opinion, it goes through all kinds of stuff. There's really this one paragraph that lays out this test, what we call the Chevron doctrine. And articulating this as a test that gives agencies a trump card to play when they're in court. Because a lot of these statutes are very complicated. A lot of them are hard to read. They're hard to parse. They're hard to figure out. So convince a court that this complexity means ambiguity, and then agency, you get to do what you want as long as it's reasonable. And the late Reagan administration, the first Bush administration, and some judges on the DC circuit grasp onto this language, and what has come to be known as the Chevron doctrine is born. And what's interesting about thinking about the role that academic research has played in this period of time in the late 80s when the Chevron doctrine was being first recognized and applied and followed and argued for mostly by folks on the right, but not exclusively, to today when it's generally seen as a position on the right, broadly defined, those conservatives, libertarians, those concerned about the power of the administrative state being against Chevron. It's really interesting to see how the role that academics played in that evolution. And I want to spend my remaining time a brief overview of kind of what that transition looked like. So at the time that the Chevron doctrine became recognized as a thing, it's first worth noting that the pressure for the Chevron doctrine being a thing came initially from, or mostly from, the executive branch, and the executive branch seeking greater flexibility and a greater ability to adopt policies that were disfavored by the judiciary. So the role of academia at that point in time was in many respects trying to figure out, what is this doctrine? Where does it come from? What are its underlying foundational premises? Can we ground it intellectually? But this was not a case of where academics had an idea and then eventually the court adopted. It was really more the court used this language. There were instrumental reasons for political actors to want, and litigants to want to weaponize this language and kind of formulate it into a doctrine, and then academics had to make sense of it. Secondly, in terms of thinking about parts of the federal government that were misbehaving or acting beyond their appropriate limits, there was a lot of concern about activist judges. There in particular was a lot of concern about the DC Circuit in particular, being a court that would take broad regulatory statutes and read them in broad purposivist ways to force agencies to regulate more aggressively and more expansively than perhaps Congress had anticipated. And Chevron was seen as a way of pushing back against courts, often in the context of citizen suit litigation, using broad statutory language as a way of forcing the executive branch to do things that it did not want to do. And in this space, one of the key figures ends up being Justice Antonin Scalia, who in the context of Chevron and in a whole bunch of doctrines was thinking about, how do you push back against judges of forcing greater federal regulation than Congress had authorized? How do you push back against citizen litigation as a driver of that? How do you push back against judges being able to pour their own policy preferences into judicial decisions? Over time, though, as people started to figure out, try to figure out kind of how can we rationalize this rule of deference, this rule of letting agencies decide what the statute means as opposed to Congress, you began to see develop in the academic literature concerns about how to rationalize Chevron, particularly where Congress had not provided explicit instructions to defer to an agency. As the Loper, Bright, and Relentless decisions acknowledge, there may be situations where Congress says expressly an agency gets to answer this question. But where Chevron was doing a lot of the work was where Congress hasn't been that explicit. And the little bit of work that I did in this area, kind of focused on some of this space about, how can we understand Chevron being based on this idea that agencies, which have no inherent authority, were actually given this power by Congress? And is it really reasonable to assume that ambiguity by itself is this not merely a permission structure, but an authority to the agency to now make these broad consequential decisions that have the force of law? And I think what you saw between Chevron and Relentless and Loper Bright is the beginning of people think, academics thinking seriously about what are the implications of a doctrine that works this way. How can we understand what its theoretical or constitutional grounding might be? And then if we've done that, then what are the contours of this? So, in my own work, a piece that Chief Justice Roberts cited, not in his Loper, Bright, and Relentless opinion, but in some prior opinions that were the precursor to it, I did a piece with Nathan Sales talking about how to think about silences in statutes and whether or not those are actual ambiguities, and why we should not understand silences as delegations of power, and more broadly, how we should be able to distinguish between an agency exercising power that was expressly delegated to it, such as how to resolve a technical question about, what a species is or what a source is or some scientific question, and how to distinguish that between questions that relate to the power that an agency in fact has in the first instance. So Nathan and I argue that it would be even within the contours of the Chevron doctrine, it would be wholly inappropriate to defer to an agency when the question is the scope of its own power. And that was something that an idea the Chief Justice picked up upon in his dissent in a case called City of Arlington versus FCC, and in some subsequent positions where he and others on the court started to recognize that the way Chevron was applying in practice was not, as, say, Justice Scalia had hoped, as a bulwark against judges pouring their own policy preferences into statutes, but rather Chevron had over time created this permission structure for agencies to aggrandize their own power, to assert authority and power that Congress had never given to them. And this was significant because it meant that Chevron, as it was operating, was not even constrained within the theoretical bounds of the underlying theory, the underlying understanding of what Chevron was supposed to be doing, which was, in theory, allowing agencies to fulfill the instructions that Congress has gave them and to exercise the power Congress has delegated to them. And I think this concern you see in opinions like King versus Burwell in the development of major questions decision, and I think you see this in the way the Chief Justice articulates the rule in Relentless and Loper Bright. So I don't go over my time. I should note that was one, so one important role that academic scholarship played was saying, okay, we have this doctrine, let's try and understand it. Let's try and recognize, is there a theoretical grounding for it? And then if we recognize that, are there limits kind of internal to the doctrine that are actually being observed? And I think that work helped both identify what those limits should be, but then also helped identify how Chevron in practice was not conforming to that, right? Justice Kennedy, in one of his last opinions, wrote a concurrence lamenting that lower courts in particular were just using Chevron as an excuse for complete abdication. We're just saying, agencies, this is complicated, do what you want to do, rather than actually thinking through, okay, is there evidence that Congress actually gave power to the agency in this kind of context to resolve this sort of problem? I should say there was also parallel research being done. Phil Hamburger, Mark, your president, your chairman, did some work talking about how Chevron is one of a variety of doctrines that allows agencies to engage what essentially is a form of prerogative power, allows agencies to change the meaning of the law without intervention of the legislature, picking up on, again, how Chevron in practice had departed from what an early Justice Scalia thought might have been an appropriate role, leading to the problem that a statute could mean one thing one year and something else another year, not because Congress had revised it, but because the agency had decided that it preferred interpreting it in a different way. So that was another line of scholarship about how Chevron in practice was butting up against other values that we recognize as being really important in our legal system, like due process, like notice, like the structure of legislative lawmaking. And I think that the confluence of these and other strains of scholarship kind of made it easier for the court to recognize that Chevron in practice was not fulfilling the role that its proponents had seen for it, and then made it kind of on the table, or I guess you should say on the wall as opposed to off the wall, to begin thinking about, okay, if Chevron isn't working, can we reconsider it, and how should we reconsider it? I certainly like to think that academic scholarship facilitated that evolution in that way. I think I've gone on as long as I'm supposed to talk, so I will stop there. But thanks.
I think it cuts straight to me. That was good stuff, Jonathan. So I want to make two brief points. The first is about the nexus of scholarship and jurisprudence. And the second one is a narrower point in which I extol the virtues of a specific mechanism to introduce scholarship into jurisprudence, and that's the amicus brief. But point one, so this pertains to the undeniable influence of scholarship over Chevron. I mean, in Gene's terms, undoubtedly the academic discussion achieved escape velocity. And this is evident in multiple ways. One obvious one, NCLA, Mark Chenoweth's group was founded, the group that brought Relentless, founded by a scholar, a motivated scholar, a great man, Philip Hamburger. Another way in which the scholarship influenced the outcome is that it conditioned the intellectual milieu. And what do I mean by that? Well, Chevron was among the most discussed, written about decisions ever in the history of American jurisprudence, and not just administrative law, but all jurisprudence. In 2014, Thomas Merrill wrote an article that I think Jonathan was referring to at the outset of his discussion, in which then there was, at that time, and this is a decade ago, there was 8,000, a bit over 8,000 law review articles that reference Chevron. And the only comparable cases were cases like Marbury versus Madison, mega cases. So again, this wasn't just a topic of robust academic discussion as a matter of administrative law. This was a mega topic in all of American law. And what does that mean? What that means is that this mountain of scholarship resulted in an atypical awareness of this doctrine. Especially as administrative law doctrines go. Every justice, every judge, every clerk, and indeed most lawyers, as Jonathan said, they get an earful of this stuff in Administrative Law 101 and Leg Reg. They were all acquainted with this doctrine. They'd all thought about this doctrine. They were all exposed to this doctrine. Ergo, that's how this intellectual climate was established. So that's an important point. Of course, that's a background issue. Scholarship was also brought to the fore directly in the case. And here, this is an amazing statistic. So the Loper Bright merits brief, their lead brief, and this is a Paul Clement production. We're talking about a fantastic brief here. The statement of the case. All right. So this is your introductory argument. You're putting your best face forward to the court, your best points. All right. So their statement of the case had 22 legal citations, of which 10 were to different scholarly papers. All right. So 12 cases, 12 individual cases, and 10 scholarly articles. That's a remarkable balance. I remember reading it and thinking to myself, yowzers, there's so much scholarship in this. I'll note as well, in terms of scholarship's direct impact, not just the many scholars and professors that were cited by both CJR's lead opinion and concurring opinions by Thomas and Gorsuch, and indeed dissenting opinions. The opinion seems to track, at least to my eyes, Aditya Bomzai's amicus brief. That is to say that unique among all the briefs that I believe were submitted to the court on the merits, I think their reasoning really does track his. And I think that's indicative of sort of direct participation, if you will, by scholars and how it can influence the case. I'll note this, sort of a coda, and this echoes what Jonathan was saying about the scholarship in both the run-up to the original opinion and in the run-up to Relentless, Loper, Bright. I just discussed how this mountain of scholarship was hugely influential to the outcome in Relentless, Loper, Bright. Well, the fact is, there were no scholars clamoring, and again, this was indicated by Jonathan. No one was clamoring for a bright line rule for mandatory deference in the run-up to Chevron. I find that remarkable. I find it remarkable that the absence of scholarly influence in Chevron proper, and then this tremendous scholarly influence in the revocation of Chevron. It almost makes me think, well, again, this is in alignment with my values, and I believe the values of my fellow panelists and also probably of many of the listeners here. But it would seem to me, at least, that we get superior jurisprudence when the judges or justices are informed by scholarship, as opposed to when they wing it with judge-made rules on the fly. All right, so that's my little spiel about scholarship. Now I want to turn to one mechanism that I've engaged in across multiple organizations before PLF at Cato, to introduce scholarship into cases, into jurisprudence, and that's the amicus brief. And this is going to be a bit of a defense because the amicus brief has incurred a bad reputation, at least to my eyes, of late. On the right, I've heard many lawyers that I respect suggest that amicus briefs are a waste of time, that courts don't cite them, they rarely cite them, and that such energies are best spent elsewhere. On the left, it's not uncommon for accusations of coctopus cabals when it comes to amicus production. I won't even deign to answer the left's complaints, but I do want to address this claim about the efficacy of amicus briefs. So here, I want you to do a little thought experiment. How do you research? How do you do research for any complicated document? I know the way I do it is I've got a number of pertinent sources up on my screen. I mean, my tabs are full. It's so much so that you can't even read the individual tabs. And I bet a lot of people, if not most, if not all, are similar. The process of writing is synthesizing these different points, bringing out new points, etc. We all know this. No one operates with just two sources on the computer screen, right? Yet there are only two parties to any given litigation, to any given controversy. So my point here is that I think that amicus briefs present a real opportunity. Again, whenever I'm doing research or whenever I'm working on a major paper, I never want for on-point sites, for on-point sources. I'm never like, oh, geez, here's another study that's talking exactly about what I want to write about. That's just not the case. So if you put yourself in the shoes of the clerks, to my eyes, amicus briefs are this wonderful resource. And to be clear here, I've always been a think tanker. I've never been a clerk, so I don't speak from firsthand experience here. But I'm talking about, I guess, what I know about writing and what I assume how others go about it as well. So this actually relates to how amicus briefs are used in sort of this surreptitious fashion. So again, I've heard conservatives bemoan the fact that it's rare for courts to directly cite an amicus brief. But that's not how they're mostly used. I mean, again, mostly they're going to be open up multiple tabs and one among many tabs on a computer screen, and they'll provide information synthesized into the brief, not necessarily cited. I'll give a pertinent example. So Kaiser v. Wilkie, a 2019 Supreme Court case. This overturned Chevron's evil cousin, or maimed and enfeebled, effectively overturned what was known as our deference. This is deference. Chevron is deference to an agency's interpretation of the statute it administers. Our was deference to an agency's interpretation of the regulation that it writes. Okay. I'm working at Cato at the time, 2019. With Cato and with cause of action, which actually brought Loper Bright, and we were working with that cause of action, John Vecchione, who is currently at NCLA. We worked with Jonathan Adler. He was on that brief. Richard Epstein, Michael McConnell. A major purpose of the brief, this amicus brief on the merits in Kaiser v. Wilkie that we did at Cato with Cause of Action Institute and these scholars, was to introduce Jonathan Adler's research on Kaiser to the court. So SCOTUS blog, it used to do this. Alas, it doesn't do it anymore, but used to do these annual stats on the Supreme Court. And among the stats they compiled were these surreptitious sites. They would use some sort of computer technology to discern where the Supreme Court had lifted or borrowed passages or used passages from amicus briefs. And what they determined in that year, in the 2019 term wrap up, was that the court had cited the Kaiser v. Wilkie, the majority opinion, had done one of these surreptitious cites for this amicus brief that I'd worked on with Jonathan, with the Cause of Action Institute, John Vecchione, who's now at NCLA. I think that's an example of a success. Similarly, with relentless Loper Bright, as noted at the outset, PLF, we filed 2 amicus briefs, one at the cert stage, one at the merit stage. I should note, Gene had said I'd written them both. Myself and my colleague Adi Diner, we were the co-authors there, so I can't claim all the credit. I had already discussed just previously how influential I believe Aditya Bomzai's professor, UVA professor Aditya Bomzai's amicus brief had been. So my point here is that these things do get traction. They're worthy, and I think that can be demonstrated. And that's largely the whole of my talk. I mean, it was, again, sort of a discussion of this nexus of academia and jurisprudence, and then second, a defense of the amicus brief as a means for joining or for introducing scholarship into jurisprudence. We're 34 past the hour. I think that's a good enough time to end. So that's my 2 cents. Thank you.
Thanks, Will. And thank you to IHS for the opportunity to visit with all of you today. Let me say that I probably wouldn't be doing what I'm doing today if it weren't for my introduction to and involvement with IHS on many levels. It really happened earlier in my career when I was in college back in the 1990s. I attended some of the IHS seminars. One of my most important mentors in college was David Schmitz, who was very involved with IHS at the time. In law school, I benefited from a Humane Studies fellowship and was mentored by Richard Epstein, someone else who I know has been involved with IHS over the years. And even to this day, Marty Zupan sits on our board here at NCLA. And the reason for that is I wanted someone whose nonprofit experience and counsel I could rely on when we set up NCLA. And I knew Marty had done wonders at IHS over many, many years and could bring that wisdom and experience to us. So IHS has really been invaluable to me personally and to NCLA in doing what we do every day, fighting the administrative state. So I wanted to start with that. NCLA is not a think tank. We think of ourselves as a do tank, which means that we're at the end of the chain of production. And so, we're not producing scholarship for the most part. Some of our attorneys sometimes will write law review articles or op-eds and what have you, but that's not the main thing that they're doing. It's an adjunct. Maybe they've written an amicus brief like Will was talking about, and after they've written the brief, sometimes turning that into a law review article can be a relatively quick thing to do, and a lot of them like to do that. But that's not the main thing that we're about. Mainly what we do is we file original litigation. We do some amicus briefs as well, but by and large, we are a shop that goes out and sues the government. And we have between 40 and 50 open cases against the federal government as we speak. And that's where that was Philip Hamburger's idea when he first started NCLA. Was he had done some scholarship with the religious liberty public interest groups earlier in his career. He was originally known as before he was an administrative law scholar, as a religious liberty scholar. And his idea was, well, what if we set up a group that looks like these public interest litigating groups for religious liberty, except we focus on fighting the administrative state? And from the very beginning, Philip, who, as Jonathan mentioned, is our founder, he's also our CEO, chairman of our board. Taking on Chevron deference was if not priority number one, then priority 1A. I think it was it was either the most important or second most important thing that we had in our sights from day one. And a lot of what we did was strategized around and built around the idea of taking on and taking down a Chevron deference. But it's tricky, right? Because you can't control on the front end which cases are Chevron cases, because Chevron is a deference doctrine that the government invokes when you sue them, and they can choose not to invoke it, or they can choose to invoke it. And sometimes, and this was one of the problems with Chevron deference, sometimes neither party can invoke it, and the judiciary can trot it out anyway. So we had that happen as well. And so I'll just briefly give you an example of two cases that we brought before Relentless. These were both cases challenging the bump stock ban, which the Supreme Court ultimately struck down in the Garland v. Cargill case at one of our cases in June. But we had another case before that called the Aposhian case. And the Aposhian case, the government had disclaimed reliance on Chevron deference. But when it went up to the 10th Circuit, two of the three judges on our 10th Circuit panel, I'm ashamed to say both of them were Kansas judges from the 10th Circuit, decided to invoke Chevron even though the government had disclaimed it, and to decide against our client on that basis, and to say that the ATF's interpretation of the statute might not be the best interpretation, but it was a reasonable interpretation, and that was enough under Chevron. That was a wrong decision for multiple reasons, including the fact that this was a criminal statute, and Chevron deference, even when it existed, really didn't apply to criminal cases. The court never got around to quite saying that definitively, but it came really close several times, and that's the way it behaved in practice. So the reason I mention this is we took that case up to the Supreme Court on the Chevron issue and whether Chevron should apply in criminal cases. The court rescheduled that Aposhian case more than 20 times before eventually denying cert in the case. And but I think that it was a case that helped get the court's attention on one of the problems with Chevron deference. And so my point being, these cases aren't rifle shots. It's not like you can just pick a case like Loper, Bright, or Relentless and say, this is the case that's going to overturn Chevron. We're going to put all our resources behind this one case and ride it all the way, ride or die. This is the one case that's going to get it done, because you may not know. We might have gotten this done in Aposhian. Will mentioned the Kaiser case in June 2019, and I think that case was very important for many reasons, but including the fact that it sort of reset the strategic landscape, if you will, because as of June 2019, when the Kaiser case came down and the court said, actually, we are going to defer to agencies' interpretations of their own regulations, but only in these circumstances, only if they sort of check all the boxes and do all these things, which was helpful. It cabined it a little bit, but it was still upholding deference at the end of the day. It led all of us who were opposing deference to try to figure out, okay, well, given that, what next? How do we take it down? And one of the things that we focused on was which deference doctrines do we think are the weakest? And there was a case called Brand X that we thought was the absolute weakest of the deference cases, weakest because it was the most problematic. I mean, under Brand X deference, even if a court had previously interpreted a statute in a particular way, if the agency came around after that and wrote a regulation interpreting the statute differently, and then that case came back up to the court, Brand X instructed the court, don't defer to you, or don't implement your former precedent. That's not what's binding on you. What's binding on you is the intervening different interpretation of the federal agency. Well, from a separation of powers standpoint, that's just a crazy rule. And so we thought that one was maybe the most vulnerable. And so we had set our sights on that. I'll back up in a second to talk about some of Philip Hamburger's scholarship, but I wanted to walk through this, this sort of strategy behind the cases. Long story short, we found a case out of the Ninth Circuit called Baldwin. It's an interesting case. Be happy to talk with you about it more. Our clients, the Baldwins, were movie producers. They produced the movie Ray. That one was successful. There were other movies that were not successful, where they lost a lot of money, and they were claiming claiming a refund on their tax return, some write-offs, and the IRS said that they never got the return. Well, to oversimplify, they proved in court that they had submitted the return. The district court ruled for them. The Ninth Circuit ruled against them on Brand X deference, and we took that case up to the Supreme Court. The Supreme Court denied cert in the case, but Justice Thomas issued a dissent from the denial of cert in Baldwin, in which he repudiated Brand X deference and talked about the problem with it. Why does that matter? Justice Thomas was the author of the Brand X opinion. And so the fact that we had cert denied, but the author of the Brand X opinion was willing to overturn or willing to repudiate his own past work on that, again, a building block, an important building block toward taking down Chevron deference, because Brand X deference is a form of Chevron deference. It's sort of Chevron on steroids. Sometimes people referred to it that way. At the oral argument in the Relentless and Loper Bright cases, the Solicitor General wouldn't even defend Brand X deference. It became a point of amusement on the court. At one point, Justice Barrett apologized to Justice Thomas because everyone was being so harsh about Brand X deference. And Justice Thomas just laughed because he'd already repudiated it. So he was sort of thought it was funny that everybody else was finally catching up to his views on Brand X deference. But it was, it was in for a thorough thrashing at the oral argument, which is one of the reasons that made us feel good about the prospects of prevailing on taking down Chevron deference. The last case, sort of pre-Relentless case I'll mention, is a case called Buffington. And it's important for a couple of reasons. We represented a veteran in that case who was denied some of his veterans benefits. He had retired, gotten some benefits, was called back to active duty, retired again after his stint of being called back for active duty, delayed a little bit before seeking resumption of his benefits. And when he sought the resumption of benefits, the Veterans Administration said, no, we're only going to give him going back a year. We're not going to give them going back to when you separated from service the second time. And they won on that issue with the VA invoking Chevron deference. And we said, well, now wait a minute. There's something called the Veterans Canon. With these benefit statutes, you're supposed to invoke the Veterans Canon in these ambiguous situations in favor of the veteran, and that should trump Chevron deference. So we pitched that issue to the court, and we pitched just overturning Chevron deference in that same cert petition. Again, cert was denied, but this time Justice Gorsuch wrote in Buffington and said that we were really giving a raw deal to the little guys like Mr. Buffington with Chevron deference. Fortunately, the court really wasn't using it anymore, and Chevron was sort of falling by the wayside, and seemed to not be being used anymore anyway, and that was a good thing. Well, when the Loper Bright cert petition came along, you saw a whole bunch of amicus briefs written saying, this was at the cert stage, saying, hey, Justice Gorsuch is wrong about that. Chevron is being used all the time in the lower courts. And just because you guys aren't using it at the Supreme Court anymore, this is a really important issue. You need to take out Chevron deference because it is a real problem at the lower courts. I don't know whether Justice Gorsuch was mistaken when he wrote that, or if he sort of knew what he was doing and was kind of tweaking people to get them to say. Maybe some of his colleagues were pitching him that line internally, and this was his way of trying to get some folks to explain in detail how much of a problem Chevron was at the lower courts. But for whatever reason, it had that effect. And so I think Buffington was another building block in getting to where the court would be willing to entertain deference. Now, the Loper Bright case and the Relentless case are really are the same issue. The Loper Bright case came up through the DC District Court and the DC Circuit. The Relentless case came up through the District of Rhode Island and the First Circuit. Both of them were looking at how the Magnuson-Stevens Act is interpreted and whether or not the agency has the power to make the boats pay for these human observers that are supposed to be on the boat. The observers have been on the boats for a long time, over 20 years. But the boats had never had to pay for it. Well, they had to provide a berth for them. They had to feed the observers, but they've never had to pay their salaries before. And that was the thing that the agency, that NOAA and the National Marine Fisheries Service was trying to do that was new, that the boat captains and companies were saying, we can't do that. We can't make money fishing for herring in the North Atlantic if we happen to pay these government agent salaries as well. And so both of the cases lost at the lower court. The DC Circuit did a pretty careful and thorough application of Chevron in deciding in the government's favor. There was a dissent from Judge Walker, I believe it was, in the case that was, I think, helpful in pointing out some of the problems with Chevron. The First Circuit's decision was much sloppier. They didn't even say, and Chief Justice Roberts called them out on this, they didn't even say whether it was the step 1 or step 2 of Chevron that they were relying on and deferring to the government's regulation in the case, but they ruled as well. And so when the case got up to the Supreme Court and they granted cert, and one of the reasons that cert was granted to Relentless when it had already been granted to Loper Bright is that Justice Jackson was recused from the Loper Bright case because she had been, even though she didn't sit on it in the DC Circuit, it had been assigned to her to sit on before she went to the Supreme Court. And so that was, it's sort of an automatic recusal situation. So they were only going to have 8 judges or justices rather deciding Loper Bright. And such a big case, I think they didn't want to run the risk that they might have a 4-4 split on that. So by granting Relentless as well, they were able to obviate that possibility and also provide Justice Jackson an opportunity to weigh in on the case if she wanted to do that. So that's one of the reasons why both cases were granted. But I think the other reason possibly that both cases were granted is it was interesting for the court to have a sort of careful Chevron analysis to review and a sloppy Chevron analysis to review. It enabled the court to more thoroughly explore some of the problems with Chevron deference. Now I want to hop back to the production of ideas and why it mattered in these cases. And in particular, wanted to mention Philip Hamburger's 2016 George Washington Law Review article entitled Chevron Bias. And it's a piece of scholarship. It's not the easiest of reads, but if you're really interested in this topic, it's well worth reading because it's where Philip first expresses in detail his view of why Chevron is wrong. And it's a view that had not been articulated as fully or as well or even at all to some extent in prior scholarship. And what Philip said was that there are really 2 major problems with these deference doctrines. And the first one is that they violate judicial independence, that Article 3 goes to great lengths to protect the independence of the judiciary, that our federal judges, part of the office of being a federal judge is providing your independent judgment. And Chevron does away with that, right? To the extent that there is any legitimacy at all in the administrative law area or in the administrative state, and NCLA tends to think there's not very much, but to the extent that there is, you have to have front-end authorization by Congress for what the administrative state is doing and back-end review by the judiciary for what it's doing. And Chevron got rid of both of those things. On the front end, it got rid of congressional authorization because it said, well, you don't need that. A gap or a silence in the statute is enough to empower the agency to go forward. And it got rid of back-end judicial review because it said, well, no, you shouldn't apply your own independent judgment, judges. You should defer to what the executive branch's interpretation of the statute is. Well, you can't take away both of those guardrails from administrative law and expect good things to happen. And in fact, post-Chevron, what we saw was a whole lot of bad administrative action of agencies doing things that Congress never authorized them to do. And we still see that now. But I think the Supreme Court has had enough. And it's, I think that the pendulum is starting to swing back the other way. The other thing that he said in that article is that, well, let me finish the judicial independence point. It's also sort of a judicial ethics problem. Judges are supposed to be giving their best view of the law, and by the Supreme Court saying, no, you have to apply judicial deference, you're really putting these judges in a bind. They've sworn to apply the Constitution, they've sworn to uphold the law, and you're telling them to rule in a way that's inconsistent with what they actually think the law holds and what the law means. And that creates a real ethical dilemma for judges as well. And Philip pointed to that. He also pointed to the fact that there's a due process problem. And the way I explain it is, if you're suing the government or the government's suing you in one of these administrative cases, and the judge has pre-committed to favoring the other side's, i.e. the government's interpretation of law, how are you getting a fair trial? The answer is you're not. It's not a fair trial. You're not getting an equal chance at prevailing from that judge, because the judge has been forced, or had been forced by Chevron deference, to put a big thumb on the scale for the government, who's already the most powerful litigant out there. And so that was a real due process problem as well. And again, folks hadn't made these challenges before. And if you look at the decision from Chief Justice Roberts, the thing that he really focuses on is the text of Section 706 of the Administrative Procedure Act. And we can get into that a little bit more if people are interested. But essentially, the text says that statutory and constitutional interpretations need to be done by the judiciary. Everyone always understood that constitutional interpretations weren't something you were going to defer on. So if statutory and constitutional interpretation was being talked about in the same phrase with what the judges were supposed to do, it was pretty clear that the judges weren't supposed to were supposed to use their own independent judgment in those cases. And this will be my final point. But Chief Justice Roberts didn't just focus on the text of 706. The beginning of the opinion, he goes back and spends a lot of time talking about the importance of judicial independence and how it's really significant and a big part of the American tradition. And that what 706 did was actually instantiate that in law and codify that role of the judiciary. And so even though he didn't rule on a constitutional basis, he really grounded the textualist decision on this history and tradition of judicial independence in the United States, which I think is very important, not only for making this decision stronger and have a more solid basis, but I think it also makes it harder for Congress to come back and unwind that and try to restore Chevron deference by statute, because I think Chief Justice Roberts has sort of put a shot over the bow here to say, you try to do that, there's a really strong constitutional argument, i.e. the Philip Hamburger argument, as to why this Chevron deference is unlawful. So, we were able to take all of these ideas, work with Roman Martinez and his team at Latham and Watkins, who we hired to do this case for us at the Supreme Court stage. John Vecchione, who Will mentioned, had argued it for us in the District of Rhode Island and the First Circuit, and he and I sat at council table with Roman at the Supreme Court. But I'll just close by saying that Chevron stuck around for 40 years in part because no one had raised these particular challenges before that ultimately prevailed. Even in the Kaiser case, where we had raised these in an amicus brief, Justice Kagan sort of gives it the back of the hand at the tail end of the opinion and says, well, the parties didn't really raise this, so we're not going to focus on these constitutional arguments. But the arguments you raise obviously matter. Scholarship matters to helping get those arguments up there and help them percolate. Amicus briefs are part of that. I think other judicial opinions are part of that, from even state Supreme Courts and things like that. We didn't talk about that, but we can go back and talk about that some more. And getting all those ideas up to the court helps to bring about really tremendous watershed opinions like the Loper, Bright, and Relentless decision from the court at the end of this term. Thanks, Jean.
Thank you guys so much. Lots of information there. We only have a little bit of time for a Q&A. There's a lot of questions, but I think I could join them together into mostly like one giant question I think they're all getting at. Also, feel free to reach out to the speakers if you have any follow-up on something they said, if you have more questions afterwards. But basically, what everyone seems to want to know is, what are the next steps for administrative law challenges following Chevron? What does this mean for non-delegation? Does this give Congress a bigger role that they do not have the capacity to fill? What does judicial review of administrative rules look like after Loper? So basically what all of these questions have in common is what next? And I'd like to get the speakers 60 seconds, and I will cut you off. I apologize for that in advance. Take on the answer, again in order, starting with Jonathan, Will, and then Mark.
So, I don't think that this augurs much in terms of non-delegation. I think the court's been backing away from that and looking for alternative routes, probably because I don't think the court thinks it knows what the test would be. One thing that the scholarship in this area really helped with in terms of making Loper, Bright, and Relentless possible was helping the court understand what a world without Chevron might look like. I think going forward, a lot of the action is going to be understanding in various ways what due process means in the context of the administrative state. We're seeing hints of that in some other cases from this past term, like the Jarchese decision. But I think that's really where the most fertile ground is going forward.
Nice. The blitz round, very quickly. So what's next? As a regulatory matter, God willing, the agencies take a hint and temper their expansive, adventurous, tenuous interpretations of ambiguous statutes. I mean, that would be the most wonderful thing, given the agency's response to West Virginia v. EPA. I'm not holding my breath immediately, but God willing, with time, that'll happen. And the other quick thing is, a jurisprudential matter, what the heck did the Chief Justice mean with this statutory stare decisis stuff? So regarding all the Chevron Step 2 decisions that are on the books in lower courts, it is pretty much an open, or at least as I understand it, and maybe my panelists know better than I, but it seems like a pretty darn big matzo ball hanging there with respect to how to proceed there. There was not a great deal of direction coming out of CJR's decision on that matter, that crucial matter.
I agree with Will that that's hanging fire. I think that one of the main next things that's going to be looked at is the Humphreys executor decision, which is the independence of these federal agencies, whether that's going to be sustainable in the modern era where the agencies are exerting executive power on an everyday basis. PLF has a case that they're pursuing in the Humphreys executor area. So does NCLA. I think there's actually another case that may get to the court before both of those, but I think that's a big issue. I tend to agree with Jonathan that the court's shying away from the non-delegation sort of redefinition, but I do think that it's waiting to see if the major questions doctrine and what it's done now with the combination of relentless and Jarchese restoring jury trial rights, which, remember, what's important about that is juries would be the ones making the fact finding now and not the agencies. And so that combination could be really powerful as well. And there may not be a lot left for non-delegation to accomplish. So we'll see what the court does, but definitely Humphreys executor is on the chopping block.
I feel like you all have experience in doing closing remarks in court because you guys were all exactly in your time. Thank you again to the panelists so much for joining us. I left in the chat. Please join us next Monday for Eric Alston talking about emerging technology. And again, look more for other examples of how ideas have achieved escaped velocity from IHS. Thank you, everyone.